Welcome to our discussion on constructive dismissal in Covina. We'll explore key aspects of California employment law, focusing on wrongful termination, employee rights, and employer misconduct. Let's delve into how these issues impact Covina workers and the legal remedies available. Constructive dismissal occurs when unbearable conditions force an employee to resign, treated as a termination. Essential evidence includes complaints, emails, and a detailed resignation letter. Most claims succeed when linked to illegal conduct like harassment or retaliation, not minor issues. This guide explains constructive dismissal under California law, claim building, and potential remedies. Not every resignation is a dismissal. Only extreme or unlawful conditions meet California's legal bar for constructive dismissal. Success hinges on strong documentation and timely complaints. Legal remedies include damages, unemployment, or reinstatement. Act swiftly and seek legal advice to protect your rights if forced to quit. Constructive dismissal occurs when an employer's actions force an employee to resign. Key elements include intentional creation of intolerable conditions, a pattern of misconduct, and whether the employee gave a chance to correct the issue. Courts assess if a reasonable person would resign under such conditions. Understanding these factors is crucial for a successful claim. Recognizing constructive dismissal in your workplace involves identifying legally actionable conditions. Common triggers include discrimination, harassment, and retaliation under the Fair Employment and Housing Act and Labor Code Section 1102.5. Real-world examples include repeated harassment ignored by human resources, demotion after reporting safety issues, and threats for refusing illegal acts. These are serious legal violations, not mere workplace grievances. Ongoing racial harassment ignored by human resources is legally actionable under the Fair Employment and Housing Act due to employer inaction. Retaliation after whistleblowing violates Labor Code Paragraph 102.5. Threats of termination for refusing illegal acts breach public policy. However, poor performance reviews, undesirable shift changes, and isolated incidents like being yelled at once are not sufficient for legal action. Start documenting immediately. Record every incident with detailed names, dates, locations, quotes. Report issues in writing to human resources or supervisors, keeping copies. Follow complaint procedures to show you gave the company a chance to resolve issues. Consult an employment attorney before resigning. Resign in writing stating intolerable conditions and referencing complaints. Avoid unnecessary resignation delays. Text messages or emails from a supervisor can be strong evidence if they contain harassing or retaliatory content. Witness statements from coworkers and personal journal entries provide moderate support. Medical records and performance changes are supportive. A single severe incident like an ultimatum to commit a crime can sometimes suffice. Always document and give a final written complaint before resigning. In Covina, if you have a viable constructive dismissal claim, California law offers remedies like lost wages, future earnings, emotional distress, punitive damages, attorney fees, and possible reinstatement. Start with a California Civil Rights Department or Equal Employment Opportunity Commission filing. Act promptly due to statutes of limitations. Most attorneys work on contingencies, so you pay nothing unless you win. Most constructive dismissal claims fail due to California's at-will employment framework, which allows significant workplace changes. Success hinges on proving statutory violations like Fair Employment and Housing Act discrimination. Timing is crucial. Resigning too soon or too late can weaken your case. Strong claims are anchored in specific legal breaches, not general unfairness. At Hooprich Law, we advocate for Covina workers facing forced resignations, discrimination, and hostile environments. We offer free consultations and work on contingency, ensuring cost isn't a barrier. If your resignation wasn't voluntary, explore our resources on workplace rights and contact us for a confidential case review. California courts require intolerable conditions for constructive dismissal, not just unpleasant ones. Key evidence includes human resources complaints, supervisor emails, and a resignation letter. You may qualify for unemployment if you left with good cause. Resign promptly after reporting issues to strengthen your claim.